This is as delicious as a bowl of Martha Stewart's one-pot pasta.
This has been the hot potato, hasn't it? Let's be honest. Martha Stewart, the doyen of all things, well, entrepreneurial and cooking, and the former D-list cable TV actress Meghan Markle.
Meghan can't have anything written about her without filing a lawsuit, threatening a lawsuit, having her people call, issuing some nasty barb back, even if it's an 85-year-old who said something very innocuous about her. She can't stand it.
She gutted that chick for all it was worth. She just put the knife in, eviscerated, got rid of the innards. I thought she was brilliant how she did it.
You know, chums, I told you this would get bigger and bigger and bigger.
There is a claim circulating that Meghan Markle is taking Martha Stewart to court. Look for the paperwork, and there is none. No filing, no legal threat, no demand letter, no lawyer instruction has surfaced anywhere. So why did a courtroom rumor spread this fast? Because the trigger was real.
I had dinner with Meghan Markle the other night. We were both guests at a dinner party in California, and she had just gotten back from the palace. I didn't talk to her really more than to say a couple of words, but I know she was talking about it.
Within days of Martha's interview, people reported that a source who hosted the dinner and sat beside Meghan disputed part of her recollection, calling it simply untrue. That fast correction felt familiar. Correction, formal complaint, lawyer letter, and full litigation are 4 separate rungs on the same ladder. On the Martha dispute, only the first one has been verified.
And let's remember, the whole of the meeting with Harry was 47 minutes. Meghan wasn't there for most of it.
I just think we know that Meghan Markle is an actress, or purports to be an actress, and then has had a crack at that didn't work, had a crack at being a podcaster, that didn't work, had a crack at being a royal, she couldn't cook it, you know what I mean? So we kind of know, but nobody's bothered.
Martha Stewart said 2 different things in that interview, and only one of them started a fight. In early August, people published a wide-ranging conversation with Stewart, and part of it touched on Meghan Markle's move into homemaking television. That was ordinary commentary from a woman who built an empire on exactly that ground. A veteran of the genre sizing up a newcomer is not a scandal, and on its own it would have vanished by the weekend.
People magazine is pro Meghan and Harry. They didn't ask her about Meghan and Harry. Martha knew exactly what she was doing.
I had dinner with Meghan Markle the other night. Well, she was at the same table, so I can't say she wasn't my guest. We were both guests at a dinner party in California, and she had just gotten back from the palace. And I think I didn't talk to her really more than to say a couple words, but I know she was talking about it.
The second thing is where the temperature rose. Stewart also offered a recollection of a shared California dinner party, describing an encounter in which, by her account, she and Meghan barely spoke. That is a memory, not a review, and memories can be checked against other people who were in the room. Within 2 days, people reported that a source who hosted that dinner and sat beside Meghan told a different story, saying Meghan had made a short, positive comment about a trip, and calling part of Stewart's account simply untrue.
A source close to Meghan saying that Martha must have been confused because the pair were not seated next to one another.
Martha said she didn't hear too much of that conversation, but she was obviously blathering on about it. And then Martha also went on to basically say, I'm not sure what this woman thinks she's up to, but going from actress to princess to domestic goddess is a very hard road to travel.
I'm sorry, Meghan. We believe Martha.
Yeah.
Martha, who has, 7 decades of telling us the truth. What you have, Meghan, is 10 years of lies.
Notice what just happened. A lifestyle interview became a contest over whose version of one evening should be believed. Not over whether Meghan can cook, not over ratings, but over credibility itself, whose word carries. Stewart said one thing, the host said another, and the public was handed 2 accounts of the same table and invited to pick a winner. That is the entire verified conflict as it stands. One recollection, one rebuttal, delivered through a magazine, attributed to a source, a disagreement about a dinner, escalated into a question of honesty. And that is precisely why the courtroom talk started.
I don't know if Martha Stewart knows that the meeting with the king back in England was supposed to be private or not, but she has done it in a very clever way.
Oh, yeah. Yeah. Oh, yeah. Oh, hi! Yes, hi! Yes, I know. It's just so lovely, isn't it? Oh, I'm so happy I got an invite.
Once a dispute stops being about taste and starts being about who is telling the truth, the pull toward a formal reckoning grows stronger. The rebuttal did not name a plaintiff or a defendant. It reframed a mild interview as a credibility fight and nothing more. So why did that single magazine rebuttal make a lawsuit feel like the obvious next move, when nothing about the rebuttal itself demanded one? The answer is not in a courthouse. It is in the way the story was framed the moment the rebuttal appeared.
Pretty much caught me eye, and oh my goodness, yeah. Let's jump into this madness, shall we? Now, when I saw this update on the home,
She decided to talk to everyone at the party about her visit with the king. Mistake number one, she's not supposed to do that.
Nobody produced a document because none exists, yet the language around the dispute shifted almost instantly from disagreement to combat. A correction gets described as a counterattack. A counterattack implies a war, and a war, in the celebrity imagination, ends in court. The coverage itself set the terms. The Daily Beast ran a piece arguing that, in taking on Martha Stewart, a hapless Meghan Markle had picked the wrong fight. The columnist did not report a filing or a legal threat. The columnist interpreted a magazine rebuttal as Meghan versus Martha, a personal contest, a chosen battle. That is opinion dressed as escalation, and it did the work that no lawyer had done. Once an outlet calls it a fight, a courtroom becomes the obvious place for a fight to end. This is the crucial distinction. A public correction and an act of legal aggression are not the same thing, and one does not quietly become the other. A source disputing a recollection tells you that two parties remember an evening differently. It tells you nothing about lawyers, and nothing about anyone's plans. Treating the rebuttal as proof of legal intent is a leap. So the real force here is not a filing, it is expectation, and expectation always has a source.
Martha Stewart is bluntly calling out Meghan. We were at the same table, but she wasn't my guest. They're not direct friends. You can't be actress to a princess to a homemaker. She can't cook. She's back from the palace and talking a bit about it. She didn't keep it private. Yes.
The framing worked because it landed on ground already prepared, a sense that a dispute like this, involving this particular person, does not just sit as two competing memories. It becomes a second battle over who controls the record. Where did that expectation come from? Not from Martha and not from a single magazine column. It came from a history, a documented sequence of what has happened before when Meghan's account of events was publicly challenged. That record is where the rumor actually lives, and it is the only place the expectation can be measured against fact. If expectation is doing the heavy lifting, then the way to test it is to look at the strongest real example of Meghan going to court. Not a rumor, but a case with a judgment attached.
And this is because, of course, you're talking about two women, whether you want to agree on the second one or not, but very powerful women in the world who both know they can command attention, they can command headlines and worldwide interest.
That example is her action against Associated Newspapers, and it is the case every lawsuit rumor quietly borrows its credibility from. Here is what it actually concerned. The newspaper published the contents of a private letter that Meghan had written, not a review of her work, not an unflattering opinion of her character, not a columnist calling her difficult. A private piece of correspondence, reproduced for the public to read. That distinction defines the right she was defending. The case was about whether a person's private letter can be printed without their consent, and about who owns the words once they have been written down. Those are two separate legal questions, privacy and copyright, and Meghan brought both. In 2021, the High Court granted her summary judgment on the central privacy and copyright issues. Summary judgment is not a narrow technicality. It means the court found those core questions clear enough to decide in her favor without sending them to a full trial. On the points that mattered most, she won. What that result establishes matters, and so does its limit. It establishes that Meghan is willing to litigate and willing to carry a fight through to a judgment rather than let it fade. It establishes that at least one of her major legal battles rested on a basis a senior court was prepared to validate. When people say she takes people to court, this is the case that makes the phrase feel earned, because here it is, simply true. But it establishes something narrower than the rumor needs. This was not a lawsuit against criticism. Nobody was taken to court for saying her cooking show looked awkward, or for doubting a dinner party memory, or for writing that she had picked the wrong fight. The trigger was the publication of a private document, which sits in an entirely different legal category from an opinion, a bad review, or a disputed recollection. Winning the right to keep private letters private does not prove that a person cannot tolerate being disagreed with in public. So the litigation rung is real. It is documented, it succeeded on the points that counted, and it shows a clear readiness to use the courts. That is solid evidence of how Meghan responds when she believes a genuine line has been crossed. The question is, what happens when the line being defended is no longer a private letter, when the offending material is not correspondence at all, but criticism spoken openly, on television, by a man giving his opinion of her to the public?
Remember that famous Piers Morgan walkout? I was actually on the show that day talking about the Oprah interview, and he said that he didn't believe a word that Meghan had said in that interview with Oprah.
A privacy case has a clean legal spine, a right that either exists or does not. A formal complaint about what someone said about you on air is a different creature entirely, and that is where the pattern begins to sharpen. The clearest test of that distinction is the case where the offending words were exactly that, an opinion delivered on live television. In 2021, Piers Morgan, then a host of Good Morning Britain, said on air that he did not believe Meghan's account of her own experience. This was not the publication of a private letter. It was a broadcaster stating, on national television, that he doubted her word. That is where the response moved to a different rung. Meghan made a formal complaint. The reported basis of that complaint was specific, and it matters. It was not simply that Morgan had insulted her. According to what ITV reported, her concern was the potential effect of his comments on other people discussing mental health issues, the message it might send to anyone weighing whether to speak about their own struggles. The complaint was aimed at the broadcast's wider impact, not only at the man who made it. That complaint did not stay in-house. It went to Ofcom, the broadcasting regulator, which meant an outside body would decide whether the program had breached the rules. 3 separate events get collapsed into a single story here. There was Meghan's complaint, there was Morgan's departure from Good Morning Britain, which followed, and there was Ofcom's ruling, which came later still. Treating them as one act gets the sequence wrong. Morgan left the program. His exit is real, and it is often described as though the complaint reached out and removed him. The evidence does not support that shortcut. A complaint was made, a departure happened, and the space between those two facts is not something the record fills in for us. Then came the regulator's verdict, and it did not go the way the complaint might have suggested. Ofcom found the program not in breach. The reasoning is the part that counts. Morgan was entitled to express strong views, and those views had been extensively challenged on air by other presenters and contributors. Because the disbelief did not go unchallenged, the broadcast stayed within the rules. Ofcom did not rule that Meghan had lied, and it did not rule that Morgan's doubts were correct. It ruled only on whether the broadcast breached standards, and it decided that it did not. That sequence proves something specific. A formal institutional complaint can carry enormous public and institutional weight, putting a national broadcast under the scrutiny of an outside regulator, even when the disputed speech is ultimately judged protected. The complaint rung is powerful precisely because it sets that regulatory machinery running, regardless of whether any finding ever concludes that the criticism crossed a line. This was an active escalation in response to public criticism. It was not a lawsuit, and no court was involved. But a complaint about opinion has a ceiling. A regulator can always answer that strong views are allowed. The response changes character entirely when the objection is no longer about an unfair opinion, but about a report claimed to be false, and when the people who raise it are lawyers. The next example is exactly that shift. It moves from an opinion nobody could prove false to a report that Harry and Meghan insisted was false in fact. The subject was their daughter's name. The BBC reported on the question of whether the couple had consulted Queen Elizabeth II before naming their daughter Lilibet, a version of events that touched on what had, or had not, been said within the family. Their answer did not go to a regulator, and it did not go to a courtroom. It went out through lawyers. Reuters reported that legal representatives acting for Harry and Meghan wrote to media organizations, describing the BBC's account as false and defamatory. The phrasing was pointed. Not unfair, not unkind, but false and defamatory. The language of a legal claim rather than a complaint about tone. This matters as a category of its own. A regulatory complaint asks an outside body to judge a broadcast against its standards. A lawsuit puts a dispute in front of a court, on the record, with a judge at the end of it. A lawyer letter sits between the two. It carries legal weight, it names a legal wrong, and it can be sent within days, long before anyone files anything. It is a warning shot fired on legal letterhead, and it does not need a court to have an effect. Its power is the implication that a court could be the next step, with no filing yet in existence. It was also a joint response. This was not Meghan acting alone. The lawyers acted for Harry and Meghan together, and the challenge belonged to both of them. What the letter did not do is settle the underlying question. The report existed, the denial existed, and the legal challenge existed, but none of that establishes whose account of the private conversation was correct. The dispute over what was actually said within the family stays open. What is closed is how quickly a contested piece of reporting could draw a formal legal response. So the pattern now has 3 distinct rungs on display: a public correction, a formal complaint, and a lawyer's letter alleging falsehood. Each one answers criticism with escalation rather than silence. But every example so far has turned on words, opinions, accounts, reports. The next one does not. It involves photographs of a child and an allegation of harassment, and that raises a harder question about whether every legal warning belongs in the same story at all. The clearest test of that harder question sits in Canada. In 2020, Time reported that lawyers for Harry and Meghan warned of possible legal action after photographs of Meghan and her son Archie were published, with the couple's side alleging paparazzi harassment. This looks on its surface like more of the same. Lawyers again, the threat of legal action again, a media organization on the receiving end again. But the thing being protected is not the same thing at all. A warning over published photographs of Meghan and her young son, paired with the couple's allegation of harassment, is a response to the exposure of a family, not to a judgment of Meghan's work. The Associated Newspaper's case concerned the publication of a private letter, a matter of privacy and ownership of one's own words. Neither of those is a review, a disputed dinner party memory, or a columnist questioning whether a homemaking brand feels authentic. The distinction is the important part. Alleged harassment involving a child, and the printing of private correspondence, engage rights that most people would recognize as real, rights to privacy, to safety, to control of what belongs to you. Criticism of your professional authenticity engages no such right. Doubting someone's sincerity is not intruding on their family. A warning aimed at a paparazzi agency and a complaint about a bad review are not automatically the same act, even when the same tool, a lawyer, turns up in both. None of that dissolves the pattern. The mechanism is strikingly consistent. Lawyers retained, legal action threatened, escalation preferred over silence. What changes is the justification. Sometimes the trigger is a real privacy or safety interest. Sometimes it is nothing more than unflattering commentary. The response reaches for the same instrument regardless of which of the two it is answering. That consistency of instrument, set against a shifting justification, is what makes the pattern worth measuring, rather than waving away. A warning grounded in alleged harassment of a child stands on far stronger ground than a complaint about a review, and it cannot be used to lend that legitimacy to every other escalation. Pointing to the strong cases does not prove that criticism of choices or conduct deserves the same forceful reply. Once the strong cases are set aside, the tally changes. The harassment warning belongs to a category of genuine safety and privacy interests. The private letter belongs to a genuine privacy right. Both come out of the pile. What remains is every dispute where no such right was at stake, and that remainder is what decides whether a pattern really exists. When the only thing on the table is ordinary criticism, disputed accounts, and unflattering opinion, does the same reflex to correct, complain, and escalate still appear? With the private letter and the harassment warning set aside, the two cases where a genuine legal right was in play, something still remains. What remains is a consistent response to disputes that were never about privacy or safety at all. Those remaining disputes have something in common. A magazine recollection is contested, and a source who was at the dinner pushes back in print. A broadcaster says he does not believe her, and a formal complaint follows to the regulator. A report about a private family conversation is called false, and lawyers for Harry and Meghan send letters. Different actors, different legal bases, different merits, and very different outcomes. One ended with a regulator siding with the broadcaster. One never reached a courtroom. One was an attributed rebuttal, with no sign that Meghan arranged it at all. Treating them as identical would be a mistake. But they rhyme. In each case, a dispute over reputation, factual accuracy, or control of the public account did not simply run its course and fade. It produced an active countermove, a correction, a complaint, a lawyer's letter. The specific tool changes with the stakes and the actors, and sometimes the couple act together, while other times the record shows only a source or a single complaint. What holds steady is that a contested account rarely stands unanswered. This is where the lazy summary gets it wrong. The pattern is not that Meghan sues her critics. The private letter case aside, most of these episodes are not lawsuits at all, and one of them may not have involved Meghan's instruction in any form. The sharper reading is this. When Meghan's version of events is publicly challenged, the challenge tends to generate a second story, the story of the response itself, layered on top of the first. The rebuttal becomes news. The complaint becomes news. The lawyer's letter becomes news. The original disagreement soon competes with the reaction to it for the headline. That layering is the real signature, and it recurs whether the original complaint was strong or thin. On the receipts, that conclusion holds. It does not require reading anyone's mind, and it does not pretend the strong cases were weak. A privacy victory earned in court is real and stays real. It simply does not settle the separate questions about how choices, contradictions, and disputed recollections get handled when no such right is at stake. Each of those has to answer for itself. And that is why the Martha rumor traveled without a single verified fact behind it. No filing against Martha Stewart has surfaced, no legal threat, no demand letter, no lawyer instruction, no announced action of any kind. Yet an audience that had watched contested accounts repeatedly turn into a public counter-record had already been taught what usually comes next. The courtroom was never reported. It was extrapolated from a history that made escalation look like the familiar ending. The catch is who the opponent is this time. Every earlier fight was over privacy, broadcasting, or the truth of a report. This one is over homemaking, taste, and lifestyle authority, and the person on the other side has owned that ground for decades, and its rules are not the rules of a courtroom. That last contrast decides what a real fight here would cost. Martha Stewart has spent decades as a recognized authority in homemaking and lifestyle media, territory settled long ago. Meghan is still building her standing in that same space, still asking audiences to accept her as an authentic voice in it. Those are not equal footings, and a drawn-out dispute would put the gap on permanent display. That is what makes Martha an awkward opponent. A prolonged back and forth would not settle who remembered a dinner correctly. It would keep the cameras on the comparison itself, an established name against a newcomer whose positioning is still contested, on ground where Martha has nothing left to prove. The Daily Beast framed the rebuttal as Meghan picking a fight with Martha, but that framing is a columnist's interpretation, not proof of anything Meghan actually did or intended. Pushed past a single published denial, the story stops being about what Martha said. It becomes about the machinery of the response, the same second story from every earlier dispute. A privacy case won in court does not buy immunity from that. It settles a legal right. It does not answer for how an unflattering comparison gets handled when no right is at stake. So the verified picture is narrow. No lawsuit against Martha Stewart, no legal threat, no demand letter, no lawyer instruction, no announced action of any kind. The dispute sits where it began, at an attributed public rebuttal, and nothing more. What has been exposed is not a courtroom, but an expectation. The assumption that criticism touching Meghan will summon a corrective counter-record. That expectation was not built by a Martha lawsuit. It was built by the history already on the table. And if it were ever acted on here, the arithmetic would favor Martha. A public fight over lifestyle authority rewards the person who already owns it, handing Martha the stronger position and leaving Meghan defending contested ground. That same battle for control does not only play out in courtrooms and at complaint desks. It runs through the quieter work of managing an image day by day, and that is where the next video takes the pattern one step further.